Sorry, Miss Savage, I've left one of the authorities bundles behind, but we can get on without it, I expect.
I'm grateful, my lord. Before lunch, we finished looking at the case of Ram. If I can next go to the case of Vadiki, which was the Times Law report, the very oldest of the cases.
Yes, that's the one which I left behind, but it doesn't matter, I'll manage without.
It's very short, and perhaps I can read
I remember it.
I
don't think we need it. You can always get the full transcript, can't you, of those older cases? You used to be able to from the Bar Library.
We tried to, tried our best, but
I don't
think that electronic sources have overtaken.
But I'm really only wasting time while when I was a young chap, you would go along to them, and they kept all the courts. Yes. Or is it? It's another divisional court one, isn't it?
It is a divisional court.
That will be the reason why. Okay.
So it's the Times Law report that doesn't actually set out the judgment in full, but like the Solicitor's Law Journal, which is in the authorities bundle, it gives a report of the authority.
Anyway, don't worry, it's good enough, I'm sure, and I've got it in my head.
My Lord, I'm grateful. So the case of Vadiki, which is a divisional court judgment,
it actually precedes Ram, doesn't it?
It does. It's 1977, and it concerns the unlawful detention of a migrant who was from Nigeria, who was considered to be exempt from immigration control under Section 8 of the Immigration Act. However, his certificate went out of date, and contrary to his certificate of exemption going out of date, his passport was stamped at the airport with purported lawful admission. He was then detained whilst in the UK because it was said that he was in the UK as an illegal entrant under the relevant act, and he applied for a writ of habeas corpus. Mr. Justice Peter Payne, so far as clear from the Solicitor's Law Journal, gave the only judgment, holding that the applicant had discharged the burden of producing a passport which, on its face, held that he had been regularly given leave to enter, and the Act did not prescribe a procedure for giving leave to enter, and that the onus for showing that the applicant was not given leave to enter was on the Secretary of State. He then addressed the Section 4 notice in writing requirement under the Act and held that that was merely directory. In all the circumstances, the court concluded that the Secretary of State had not discharged the burden on him, and that the applicant should be released under a writ of habeas corpus. That decision is one that we do rely on, albeit that it's a decision of the administrative court, and it has been doubted in the case of Baga, which the Secretary of State relies on, and that's in the authorities bundle at 14. That concerned, again, the question of exemption from immigration control, and whether the applicants in that case were correctly considered to have been exempt from the requirements under the Immigration Act because they were purporting to be employees of a diplomatic mission. And a number of cases came before the court. If I can just read from a head note.
Yes, this one I don't remember so well. I was hoping my clerk would have arrived. I'll look over my ladies.
Lord, would it assist if we were to hand out a copy of the authorities bundle? It's,
oh, that's very nice of you. By the time it arrives, my clerk will have arrived, but that's... It's only this. I only want the volume 1. Thank you. Oh, I told you.
Like buses.
But then, if you hadn't offered it, you wouldn't have arrived. So,
exactly.
Thank you.
Okay. I'm very grateful. So it's tab 14, my lord.
Yes, thank you.
And one looks at page 573 in the headnote first, some halfway down the page at D, held allowing the appeals of the Secretary of State 1 that the exemption in Section 8.3 of the Immigration Act from the provision of the Act applied to anyone who arrived in the United Kingdom to take up employment as a member of the mission, or who was in the UK and took up such employment, whether or not the Foreign and Commonwealth Office had been notified, and that was one of the arguments, and that therefore, since all 6 applicants had been appointed as members of a mission or members of such an appointee's family, they had been excluded from the provisions of the Act, and they could not be the subject of a grant of indefinite leave to enter the United Kingdom under the provisions of the Act. Your particular reference to those words. So there was no power under the Act in the case of Varga to grant leave because, contrary to the immigration officer's assessment, they could not properly construed be exempt, and they were not exempt from immigration control under Section 8 of the Immigration Act. And therefore, the date stamp applied to their passports merely recorded the date they entered the UK. I also draw your Lordship and Ladyship's attention to paragraph 2 of the headnote in F to G, where in the case of Varga, with which we are particularly concerned with, deception had also been found and not disturbed as irrational or unlawful by the Court of Appeal. And it's right for me to just point out the facts of Varga, which are at 576, where Lord Justice Parker sets out the various stamps that he was given and that he was considered visa exempt. We find that from 576 between D and E. Lord Justice Parker then concludes on the first issue in the case of Varga at 582 F that as of 8th of July his employment ceased, and therefore he was here without leave, so in other words he could not have been exempt from immigration control beyond that point. And then the question arises of what to make of the stamp that was given to his passport in the mistaken belief and, critically, out with the statutory provisions that he was exempt from immigration control under Section 8. And if I can invite my lords and my lady to read page 583 from these, 583 to 585.
Okay. Yes.
So, a couple of things to draw out from that case. The first one is that in our respectful submissions, there's nothing in the case of Varga with which our case is inconsistent. And that's because Varga was accepted to have involved a situation where there was no statutory power, lawful authority, to grant leave. And that's the basis on which Lord Justice Parker reaches this conclusion at 583 FG that a mere stamp does not, in itself, purport to grant leave. In our case, we say there clearly is lawful authority to grant leave. The second point to draw out from that is the requirement of written notice in section 4, and one can see that there is a disagreement between Lord Justice Parker and Mr. Justice
Peter Payne
in respect of whether that is directory or mandatory. And what we say is that even on the judgment of even on the judgment in Varga, there is clearly a door left open for a factual scenario, and that's at 583 H, which would allow for a possibility that the date stamp would satisfy the requirements of written notice if, and the situation posited there, a factual matrix, for example, meant that that was routinely done. And on our facts, we say that this is also a prime case where the factual matrix is such that it naturally leads to the conclusion that the notice requirement in writing is satisfied by the stamp itself. And the third point to note about the case is, of course, the issue of exemption, which I accept to form the basis of the legal assessment, but nonetheless is a point that should be noted by the court in terms of how it approached the consequences of the mistake. Next, if I can deal with the case of Musico, which is a more recent authority concerning an entry clearance officer's mistake. That's in the authority bundle at tab 33 in volume 2. It's an authority that Lord Justice Lewis will be very familiar with, having both given judgment in the case. This concerns, by way of a reminder, an entry clearance officer who mistakenly, and on the facts particular to the case, concluded that the appellant was exempt from immigration control. And paragraph 46 is of particular relevance in terms of the assessment of the case of Ram, which we considered just before lunch, because my Lord Justice Lewis looked at and considered the decision in Ram and concluded that it wasn't applicable to the facts of that case. If I can refer to some three lines from the bottom of that paragraph, there was no question of her, that is the appellant, being granted a status by the entry clearance officer in the exercise of statutory power, and that was said to be the distinguishing factor in the case of Musico. There was no need on the respondent to revoke or terminate any such status.
Sorry, where are you reading from?
I'm sorry, my lord, I'm at paragraph 47.
47, sorry, I was on 46.
Penultimate.
Yeah, I've got it now.
Sentence.
Thank you, I found it now.
Could I just have a page reference on that?
Yes, it's 1050.
Thank you very much.
And this is the only case where the mistake which was considered to have been made by the ECO and accepted as between the parties, did not involve some sort of deception or misrepresentation on behalf of the applicant. But critically, in my respectful submission, the distinguishing feature of that case was that there was no question of the applicant in that case being granted any status in the exercise of a statutory power. And again, we say the situation is different here because there is power here that we rely on. So in terms of the conclusion on the lawful grant of entry and the mistaken grant of leave, the questions for the court are these in my respectful submission. Firstly, was the stamp here given in the exercise of a statutory discretion and a lawful authority by which the Secretary of State is bound?
Sorry, hang on. The exercise of a statutory power.
Yes.
Well, and what was the next phrase?
By which the Secretary of State is
Something
bound.
about, no, there was some phrase about authority.
In lawful authority.
Well, I don't know what that means.
Well, on statutory discretion, we'll do.
Okay, statutory power. In the exercise of a statutory power.
By which the Secretary of State is bound. And the second question is this court bound to find that a stamp cannot, in law, operate as a formal record of a grant of leave? And
Well, we're not dealing with leave, are we?
well, my lord, I'll come on to address the question of admission and whether or not
Yes, I see, okay.
that equals.
Okay, I'll accept your wording for the time being. Yep.
The answers to those questions are firstly, yes, in our submission, the stamp was given in the exercise of statutory discretion and the Secretary of State is bound by it.
If it was given, are you saying it was given as a matter of fact, or it could have been given had the immigration officer turned his or her mind to it?
We say that in law, there was lawful authority for the grant of admission to
So the immigration officer could, had he turned his or her mind to it, have granted leave?
Yes. He was certainly empowered to do so.
Will you show us the statutory provision in question?
It's section 3 of.
But it isn't. We've just been looking at that.
Yes.
That's about grant of entry clearance. And this is about, in terms, this is a grant of admission.
Well.
Or not a record. This is a record of admission under the 2006 regs, which, as we saw from section 7A or 8A, whatever it is, are carved out from the section 3.
So our case is that the power that was exercised, or it could have been exercised, was the power under section 3 of the 1971 Act.
That's why I keep asking you whether as a matter of fact or as a matter of law, and you're saying, I think, I don't care what it actually was meant to be, as a matter of law, the only thing it can be is the grant of leave, and there's no inhibition on it being such a grant of leave. That's as I understand it, is what you're saying.
That's correct. Can I deal next with the question of whether or not entry and residence, or admission and residence, are one and the same, and the extent to which they can be differentiated for our purposes? The authority that we rely on in respect of our submission that the grant of admission must equal the grant of residence is the case of Cower, which is at the authorities bundle at 32.
The entry was equal admission. I just didn't quite catch what you're saying. Sorry. It's a
The
big
authority-
caution.
I'm
Entry
sorry,
must
Lord,
equal
it's
admission.
my fault. We say that the admission to the UK equals the grant of residence. So the case of Cower, which is at the authorities bundle 32, concerned a British citizen and his family. The family had gone to Bulgaria for a period of 19 days, and they came back to the UK, essentially asserting that the British citizen has exercised his right, his EEA right in Bulgaria, which was found not to have been genuine, but was an attempt to circumvent the UK immigration laws. And all I need to take my lords and my lady to is the judgment of Lord Justice Marlis, and I hope I'm Males. I'm grateful. Very nervous about getting names wrong. And in particular, the submission that's replicated in the judgment from my learned friend Ms. Smythe at paragraph 39, page 1030, and then over the page 1031, proposition 3, there can be no freestanding right of entry without a right of residence. And then in the judgment of the court at 1030...
Sorry, where's her submission?
The submission is recorded at 1031.
So 1031, sorry, yep. I see, point 3.
Point 3.
Yep, got it.
Right of entry. And then in the judgment, which is at 1034, again point 3, it would make no sense to say that a person has a right of entry but not a right to reside. The two are inextricably linked.
Sorry, I'm really sorry, I'm just not with you. 1033, you say?
Sorry, 1034.
1034, sorry.
I beg your pardon, my lord. Paragraph 50, which starts at 1033, and then over the page at 1034, subparagraph 3.
Well, hold on. Don't we start at 50? This
Yes.
decision does not mean that the effect of Article 5 is to confer a right. And I have in my mind that Article 5 is entry, Article 6 is initial 3 months residence, and Article 7 is continued residence. So I've got that at the back of my mind.
Yes.
And then you want us to go to 3.
Yes. So over the page, subparagraph 3, it would make no sense to say that a person has a right of entry but not a right to reside.
Mm-hmm.
The two are inextricably linked.
Yeah, but what does that actually mean for the purposes of this case? All that seems to be saying is once you get in, you get 3 months residence under Article 6. But how is that helping us? Is he saying that Article 6 and Article 7 don't matter? Once you've got admission or entry under 5, it's the same as having a right to reside granted for an indefinite period. I don't follow the link at the moment.
No, no, he's not saying that, my lord. What I say is that this principle can be cross-applied to the right of admission that's given in this case under a different statutory power under Section 3, and that once right of admission is granted, that must be linked to a right of residence.
Yes,
What do you mean by linked to?
Well, it doesn't exist. One doesn't exist without the other. So if one is granted a right of admission, then it must follow that they are also residing, assuming that they take up the admission, in the UK under some lawful
I
authority.
suppose that's so. Suppose you come in under Article, exercising right under Article 5 and leave the same day. Does that make sense to say you're residing?
Well, as a matter of fact, no. No, and perhaps that's where the distinction makes sense. There is a difference in terms of admission itself being lawful and thereafter the continuing residence.
But I thought that's exactly why you had 6 and 7, because normally, subject to returning, you just come to a shopping trip at Dover. If you come in, you usually want to stay here, certainly if you're coming to join your relative. So you come in, that is a state of it being physically lawful for you now to enter the territory. You have not broken any laws, you have been admitted. What do you do there? Answer is, don't worry, for 3 months, you have the right to reside. Now, if you want to stay longer than 3 months, you have to do something, don't you? You have to get a residence card.
Well, my lord, I agree. What I say is that this principle of the right of residence being linked and inextricably linked with the right of entry applied in the current context to the power of the immigration officer to grant leave to enter that was given in this case must mean that Mr. Vasa was also granted leave to reside because his leave to
Again, you're
enter-
confusing two different. The domestic law concepts are leave to enter and leave to remain. Leave to enter always is for a limited. Well, it either be, could be. It typically will have a duration on it. During that duration, we don't use the word reside. You're entitled to be present in the UK until the expiry of the leave granted by the leave to enter.
Well, leave
But we're not here concerned with leave to enter. We're concerned here with Article 5, which is a right to enter, and what comes with that is an initial 3 months under Article 6. I'm a bit lost by this. I'm not sure Core helps anyway, because he was addressing a particular question about the extent of the ratio in McCarthy number
yes,
2.
I accept that.
Why did you bother applying at all 2 days later? Because on your analysis, if the right to enter is the right to reside, and there's no limit, presumably, on the right to reside here, I don't know what he was doing on this 2 days after he came in applying for something else. He didn't need it in your case, did he?
Well, my lord, this brings me back to the discussion that we had in the morning. It wasn't the intention or the understanding of any of the protagonists that Mr. Vasa was granted indefinite leave to remain in the UK. What we say for current purposes is that as long as there was statutory power to grant leave to enter or lawful admission, then that in law, given the absence of any restrictions or conditions which are not prerequisites to its lawfulness, the absence of any conditions means that in fact he was permitted to stay in the UK indefinitely.
He had indefinite leave to remain.
Yeah.
And he doesn't need to apply for anything else.
Yeah, well, this is a point we went over this morning. Yeah.
Yeah.
Yeah. Okay.
And that's our case.
Yes. Thank you.
My lord, my lady, I'm slightly over my time. I did want to deal with the important trilogy of cases of Siddiqa, Alaraj, and Chelik. It's subject to...
Well, I mean, unless I'm assuming, like I made this clear before, that much of this is Mr. Metzler is really only going to have to deal, unless he thinks you've got anything wrong, he's only going to have to deal with the peculiarities of his own case.
Yeah.
In which case, I'd have thought we could easily hear you for a bit longer. If there's stuff you really need to say about Chelik and the rest, Mr. Metzler looks relaxed.
I shan't be long.
My lord, I'm very grateful. I can deal with it fairly briefly, unless invited to do so more extensively, but by the court. Can I?
Well, I think what we need to know is what the propositions relevant to your cases you're getting out of them. You don't just need to deal with them because they're important cases. What do you going to draw from these cases?
What we say broadly is that in none of these cases, the argument that is put before this court was raised. The lawful authority of a grant of leave that was mistakenly given was not raised in the case of Sadiqa. Sadiqa concerned.
Well, none of them were mistake cases, were they?
Well, Al-Araj was a mistake.
Oh, Al-Araj, sorry.
Very similar. That's the Upper Tribunal.
Okay, well, we'll come to Al-Araj in a minute, but it never occurred to me that Chalik and Sadiqa, I know Ms. Smythe relies on them for certain propositions. What, you just want to meet what she says about them?
Well, I say that we are different to both of those cases, and quite substantially so.
So Chalik doesn't, or Sadiqa doesn't help you establish your principal cases.
It doesn't.
Well, might it be more sense, unless I don't want to deprive you of an important forensic advantage, but mightn't it make more sense to deal with them in reply when we see what Ms. Smythe has, how she's tried to use them?
My lord, I'm content with
My lord,
that.
with any assistance, I was planning on addressing both of those cases in some detail since they're predinated against me.
All the more-
I'll be addressing both of
Well,
those cases.
all the more reason, I think, Ms. Savage. As I say, if you feel you'll be disadvantaged by not referring us to them, but it doesn't sound as though you will be.
No, not at all.
Al-Araj, what you do want to deal with?
Well, I don't need to deal with Al-Araj. I'm sure it will be predinated against me too. But the short point about Al-Araj is that the argument about lawful authority under Section 3 was not raised in Al-Araj, and so I don't say that it was wrongly decided. I say that it simply didn't address the argument that's being made here. Can I deal then very briefly with the concluding submissions on our grounds? And the first point about the lawful authority, the lawful power to grant entry, which constitutes facilitation. My lords, my lady, you have my propositions and my submissions on that. I just wanted to deal briefly with the floodgates argument that's been made against me, essentially that anybody, if we are right, who is granted leave would be able to circumvent the provisions in the 2016 regs and say that their residence complies. And that's not our case. Our case is very much confined by the unusual facts of this case, where a mistake was made, and a mistake where leave was granted, again consistent with Article 3. And the intention was to grant admission under the 2016 regs.
Can I perhaps just ask this, which I was going to ask at some point? We're proceeding on the assumption that these were two one-off mistakes. There's no reason to believe, is there, that what happened in these two cases reflects some general practice of immigration officers in what might be thought to be analogous cases?
Well, my lord, I'm told by Mr. Metzer, KC, that he will deal with that point.
I see, okay.
Certainly, I'm great.
Okay, and if you'll do it, that's fine.
On the second point, and that's even if I'm wrong about the lawful authority and the grant of leave, where do the principles of proportionality and legal certainty take us? I say that given the facts of this case, EU law principles, particularly legal certainty, proportionality, demand that facilitation of residence occurred. And that's because, in terms of certainty, the court, in my respectful submission, has to grapple with what is Mr. Vasa's immigration status if the Secretary of State case is right. And if the Secretary of State case is right, then he must be here unlawfully.
He must now be here unlawfully, yes. He may not have been unlawfully when he came in over the first 3 months, but at some stage, not having got any form of document, if you're wrong, then he is here unlawfully and shouldn't have remained.
Yes, but even on the Secretary of State's case, it's from minute one.
On the Secretary of State's case, it has to be from minute one. So all that time, during all of this time, he has been in the UK without lawful leave to enter, without lawful residence.
Is it a sufficient answer to that to say that if he was thought to be subjected to any penalty or detriment as a result of having been mistakenly, having been given reason to believe he was here lawfully when in fact he wasn't, I mean, it would be an abuse to bring any criminal proceedings against him. I'm not sure what other disadvantages he might be said to suffer.
Well, in terms of
Hostile environment type problems, bank accounts and things. I just don't know what you're thinking of.
so what we've outlined in the skeleton argument is only one, and it's not the most severe one. In the skeleton argument, paragraph 13, we set down that in any future application
Yes.
he makes, any period of lawful residence.
Yes, but if it was a result of the Secretary of State's own mistake, it would be unlawful for the Secretary of State to rely on it against him. So,
well, they're statutorily bound to attach little weight to period of leave that was without lawful authority. So,
Another way of looking at this is the normal principle in administrative law is if the Secretary of State has taken a decision, that decision is valid and produces legal effect until it is quashed. The Secretary of State has never applied to quash or have declared invalid the grant of admission in the stamp. So whatever she says now, or he says now, it's all terribly interesting, but they should have done it months ago if they were so concerned about it. And this was granted, and it's never been set aside. It's presumed to have legal effect in those circumstances. There are many, many decisions where that has happened.
well, my Lord, yes. Just in answer to the further consequences, we haven't put it in the skeleton argument, but my Lord is right that hostile environment would apply. Mr. Vasa wouldn't be able to work, study. He would also be subject to detention, or he would be liable for detention and potentially deportation.
well, I'm just testing with you the answer. Certainly, to any action taken against him by the Secretary of State, it would be abusive of the Secretary of State, having given him reason to believe he was lawfully here, to treat him as if he wasn't. So he'd be totally protected against deportation or anything like that.
Well, my Lord, I don't accept that. I don't accept that he would be protected from liability to detention or deportation. The Secretary of State's case, although it's not spelled out, is that the mistake in the passport means that he didn't have the relevant documentation to enter the UK, and no other leave was granted to him.
No, I understand. Of course, I understand all that, but I'm just testing with you what the detrimental consequences of that submission are if the Secretary of State couldn't lawfully take action against him.
In my submission, the Secretary of State could lawfully detain him and deport him. The question
Why
is,
wouldn't it be an abuse?
because he was here without leave.
But well, we're going round in circles.
Yes. The
Okay.
question
Well,
of-
I would have thought perhaps your better point might be the hostile environment point, which affects third parties. Though on the other hand, if third parties shown a stamp in the passport, they're unlikely to say, "Okay, but I happen to know this was unlawful."
But, my Lord, all of these scenarios are underlining the question of uncertainty.
Yes, I see your point.
It may be that it would be abusive. It may not be. Arguments can certainly be made both ways. But whichever way one looks at it, it is the definition in my submission of an uncertain immigration status. At best, an unlawful one at worst. And that's the consequence of the
Yep,
structure
okay.
And the second point that I can take much more shortly is one of proportionality, and whether or not it would be proportionate, or it was proportionate for the Secretary of State to demand, in these circumstances, that Mr. Vasa makes a further application before the end of the transition period for a residence card, in circumstances where he understood that his entry was lawful and granted under EU law, whether it was disproportionate to require him to make that application before the end of the transition period. And we say clearly it wasn't. So my lords, my lady, that concludes my submissions, subject to anything. Thank you. I'm grateful.
Yes, that formulation, sorry, it's disproportionate where he had been led to believe, I think I've got this down, that he was here lawfully.
Yes.
But that really assumes what you have to prove, don't you? He didn't believe that he was here lawfully indefinitely because he knew he had to apply he had to make an application of the kind that he made twice.
Well,
I mean, that's very close to an estoppel. It's not actually under the banner of estoppel, but you say it's disproportionate because he's been led to believe A, whereas in fact the position was B.
Yeah.
But if he didn't believe A, it's not disproportionate.
well, he believed that he was allowed to enter the UK.
Yes,
Under
that's
EU
certainly
law.
true. But not to stay here indefinitely.
No. And
The better point perhaps is that what he believed, that the most he thought he had to do was put in an application for pre-settled status they would follow automatically. And it would have come as a terrible shock to him to realise that not only did he have to do that, but they had to apply first for a residence card, even though he would have got it, and even though he was given the link. But you say the misleading was requiring him to do a further step, getting the residence card, before he got the pre-settled status, I think is...
my lord, I'm very grateful. And in addition to that, that requiring him to do so before the end of the transition period, after which he was, of course, not able to make such an application.
But I thought he was told in October he had 2 months to do it, didn't he?
He did.
And if he had put in an application for a residence card, then he clearly would have been within 10.3, and when it was granted, his residence would have been facilitated thereafter. So I can understand it if he couldn't have done it, but your client could have done it. We don't know why he didn't, but he could have done it.
He was given the opportunity to do so, yes.
Thank you.
My lord,
Sorry.
I'm grateful.
Thank you very much, Ms. Savage. It's been very helpful. Yes, Mr. Metzler.
My lords, my lady, I do intend to ensure that your timetable is regularised in the way indicated. I hope that...
Well, I hope you don't feel...
sorry, my lord.
So I hope you don't feel
Not at all.
hard done by it.
Sometimes one can recognise that submissions are made, which I very largely endorse, the submissions
Yes.
held by my learned friend, and also on my right, Mr. Mayor is going to deal primarily with 10.3, and to use a bad expression, I'm somewhat sandwiched between two, but...
Don't worry about it, Mr. Metzler. Say what you need to say.
Thank you very much, my lord. Can I perhaps start, because I think it's important that the history of how this case arose in terms of the facts and the submissions in Mr. Hasanaj's case is properly and fully understood. And can I ask you first, please, to look at page 179, which is how the grounds were drafted before the First Tier Tribunal. Probably...
tab. It's just quicker to find. 22. Thank you.
I probably formally, my lord will recall at the beginning I got up very briefly to indicate our position. Can I think I have to formally apply, unless it's already been granted, to advance the argument in relation to one amendment.
If I didn't grant it at the beginning of the hearing, I meant to. So you're all right.
Thank you. I don't need to. And I can reassure the court, I think I made it clear that we don't advance submissions that my learned friend is concerned about in relation to paragraph 10 of her response in relation to the Italian residence document. We're not advancing those submissions. Sorry, my lord. Can I return then to page 179 and paragraph 3, because I think it's important to glean exactly how the case was run, both at the first tier and in the upper tier, and the factual information, which of course I know the court is concerned with what was the factual evidence underlying the basis of the cases. So at paragraph 3, the basis of the appellant's application was that he is the dependent relative of an Italian citizen, his sister, Nicola Hasanaj. I'm going to assume, I can go to the chronology, can I assume the court is fully familiar in relation to the chronology? We did do a short chronology, I think, that was served electronically yesterday.
Yes, I haven't got that, but if there's a spare copy knocking about.
I'm sure we have hard copies. I'll provide those in a moment. Thank you. In fact, it probably makes sense if we've got them now just to pass them up because they're very short.
It did come to me and I printed it out, but
Not at all.
if you can tell my paper management isn't perfect. Thank you.
It might. I don't think we need to go to any length. It's there for your assistant in relation to the history.
Thank you.
So, the appellant and his, as it states in paragraph 3, the appellant and his sister relocated to United Kingdom in 2019, together with Ms. Hasanaj, that's his sister's, 2 daughters, who aged 11 and 4, also Italian citizens, and you'll see the background in relation to how it was that she decided, that's Miss Hasanaj, decided to leave Italy with her daughters. The appellant, who was then financially dependent on his sister and a member of her household in Italy, relocated with them as his sister's dependent, and on that basis...
How do you know that, as a matter of fact? Is there a witness statement? Is there something in the First Tier Tribunal, or is this an assertion?
It seems to be an assertion. We're going to go to the First Tier Tribunal, but my lord is absolutely right that this does look like a ground based upon some information, but not evidentially. And then the continuation, Ms. Hasanaj now has limited leave to remain in the United Kingdom under the settlement scheme granted on the 5th of June 2020, as do the children, who are granted leave on the 3rd of September 2020, and they reside together with the appellant in Essex. So that was the background. If we can now go to what happened in the First Tier Tribunal, and that, my lords, it's a little bit earlier in the bundle. It starts at 175. And my Lord Justice Lewis's observation, which of course is important in relation to the sequential position, at paragraph 5 at 176, it's clear that the appellant had representation by counsel, not counsel personally instructed, but counsel in the case. At paragraph 5, as the Lord Justice Lewis observes, neither the appellant nor his sister, Nicola Hasanaj, gave oral evidence at the hearing, nor have they produced written witness evidence. What does appear to be evidence in the case, and it can be discerned from the findings and the decision. If I can ask the court, please, to look at paragraph 6, line 4. Well, we can start at line 3. Entered United Kingdom on 26th March 2019, and according to the stamp in his passport, was admitted under the regulations, 2016 regulations. He had been living in Italy with his sister. I think we get that from the grounds, but it doesn't look like that was an issue between the parties. With his sister, an Italian citizen, and they entered the United Kingdom in 2019 with her 2 daughters, also Italian citizens. And you get this again from the grounds in relation to her marital status and the sister getting pre-settled status, as well as her 2 daughters some months later. And then...
Well, I mean, that, as you say, it's a finding, presumably, as you say, on basis of what? he was told and nobody challenged. And that would be enough for the household limb, even if it wasn't for the financial dependency limb. Because
Exactly. Can I then take you down a little bit further? Because it's important to know what evidence there was, given that what evidence there wasn't. And you can see at paragraph 7 was the submission in the First Tier Tribunal of the respondent. The issue appears to have been whether the appellant was an extended family member. That appears to be what was argued at the First Tier Tribunal. You can see that at paragraph 7.
And the final sentence.
I'm sorry, my lady.
The final sentence.
Yes, there is evidence of a tenancy and bank statements and money into his account of April 2021, but no evidence regarding dependency. Yes, my lady is absolutely right. So, again, I think it's important we see what there was evidence of and what there was not evidence of. And then paragraph 8, the submission. Counsel for the appellant submitted that the stamp in the appellant's passport clearly shows that he was admitted to the UK under the regulations. I agree with the force of that submission, as the wording is clear on the stamp in his passport. He was a family member of EEA citizen and would have satisfied Regulation 8.2, and of course you've heard the submissions that my learned friend Ms. Sabic has already addressed you. The last sentence appears to be, the first part of it appears to be, greatest respect, wrong anyway. He is a direct family member. I don't think that can be properly argued. But the second part, an extended family member as requested under Appendix EU, that appears to be the substantive finding of the First Tier Tribunal judge. And then at paragraph 9, further evidence. There is also evidence under the tenancy agreement of the landlord's letter and council tax and joint names and bank statement of the appellant showing money from his sister coming in and going out as rent, £650 on the same day. I conclude that the appellant remains a dependent family member of his sister who is an EEA citizen. So, dealing with my lady's point, that appears to be a finding on what evidence there was in terms of the documents.
One thing that's not clear to me is this seems to be a finding of dependency in the United Kingdom, i.e. the tenancy, the money going to Mr. Bonus, and the council tax and joint names. So that may be fine, and I understand it says the applicant remains a dependent family, but I haven't seen any document yet that deals with whether or not there was any dependency in Italy before they came. And he, of course, had the right to work in Italy. I don't know what the circumstances there. And you can also remind me whether or not he would have had to have been dependent both in Italy before he came, and that continued in England or Wales having arrived here.
Yes. That is, if I may say, a very accurate summary of what we have and what we don't have.
So we don't know the position in Italy.
We think it's exactly the same in Italy, but we...
Never mind, do we know, is there any evidence before the First Tier Tribunal or before us?
There's nothing before the First Tier
Tribunal. No evidence about the status in Italy.
It's not mentioned at all in the decision in the First Tier.
And would he have to show dependency in Italy before he came?
I'm grateful to Merlin Jr. Household dependency is what
well, not how there isn't such thing as household dependency, but I think what you're saying is that he was entitled to admission as a member of the household.
Yes.
And thereafter, once he'd been admitted, he was entitled to longer-term residency on the basis of dependency.
On his sister. So
that, as it were, the basis changes. Maybe it didn't need to change, but in terms of what the evidence is, he could prove one thing to enable him to be admitted and another thing to enable him to reside. Is that what you're saying?
I think it is.
Is that what your junior is saying?
I think it is. That seems to be a safe way to assume, but certainly I don't think we glean anything more from the decision in the First Tier Tribunal, which either adds to the point or rebuts it. But it looks like, there has to be, I think there has to be something to understand in relation to what the last words in paragraph 7 mean in the context of paragraph 9, because as my Lady Justice Davies observes, no evidence regarding dependency, whereas there evidence of the tenancy and the like. And we note at the end.
Well, hang on. Well, this is the respondent's submissions. This isn't the judge's findings.
Yes, but what we do have is, of course, the word remains, paragraph 9.
That's the problem. I don't see what the basis for that is, because we haven't got evidence of dependency in Italy. As my lord says, it could have been household members, because that's in paragraph 6, is living with the sister.
Yes.
But we just don't know who was working, who was looking after the children, and so we just don't, do we?
Yeah.
I'm sorry, Mark, can I just say, so that I don't misunderstand and I can reply effectively, the fact that he was living in Italy with his sister means that they were living in the same country, not in the same household, and there's nothing in the grounds to say that they were living in the same household.
Oh.
Well, I don't know about the grounds. He had been living in Italy with his sister.
Yes,
That doesn't mean it. That on ordinary English, that doesn't mean he'd been living in the same country as his sister. It surely means he'd been living with his sister in Italy.
the difficulty, because one doesn't know, I certainly read it as they've been living in the same country, but if one looks at the grounds, it says they've been living in Italy, and there's nothing to indicate, as far as I'm aware, that they were in the same household.
I'm sorry to. I'm grateful to anything. Can I return? I did want to start with the grounds because I think the grounds are important. If one returns again to 179, in the middle of the paragraph, it states the appellant who was then financially dependent on his sister and a member of her household in Italy.
Yeah, and the then is when they came to this country. Or is it not?
No, then. No, I think. Oh, so I shouldn't contradict my lord. I read that as meaning who was at that stage.
Yes.
So in Italy, he was financially dependent on his sister
And lived with her.
and lived with her.
But that is just the grounds.
Yes,
They weren't called to give
My lord, I started by saying
No,
it's
I
not
think we're in
based.
danger of getting lost. Well, I think we're dealing with Miss Smythe's intervention, which appeared to be that there wasn't even a finding that he was living in the same household as his sister in Italy. And
Yes.
I'm going to say that is how I read the second sentence of para 6. And even if the grounds aren't evidence, what seems to have happened slightly informally, but this does happen in the FTT, is that things are said, and if they're not challenged, things are said by the advocates or taken from the grounds, and if they're not challenged, the tribunal goes on and makes findings on the basis of them.
Yes. I mean, I wholly accept that it's perhaps inexplicable, certainly hard to understand why no actual written evidence comes before the First Tier Tribunal. I'm not in a position to answer that. But I think what has happened is exactly as my lord indicates. There's been an elision between something contained within the grounds that was not challenged at the hearing before the First Tier Tribunal.
But for better or worse, we have a finding. How thing is headed findings.
Yes.
It's a little bit confusing because some of the paragraphs aren't findings, they're submissions. But para 6, I do understand to be a finding. And it is a finding, as I read, about said he was living with his sister in Italy. Not that they were both living in Italy at the same time.
Yes, and I would say...
And the grounds support that.
And thank you. And I think it can be safely inferred, if not explicit, that there's also a finding that last sentence of paragraph 9 is a finding. I
It was
conclude.
dependent in England. I understand the word remains, but the only evidence is the tenancy agreement, the council tax, and the bank statement showing the money going from his sister, going into his sister and going out to Mr. Bones.
Yes. Yeah. My lord also has
Yes.
a point on the word remains. That's very strictly speaking, doesn't follow from anything he said before, because he hasn't found dependency beforehand, but that's applying a very high standard. of
It
drafting.
is, and I, with greatest respect, I'm going to suggest that remains in this context is where nothing is challenged from the position in Italy for the purposes of here in the United Kingdom. And that's why the word remains is there, because it does indicate a continuation of a relationship of dependency.
Which is what was set out in paragraph 3 of the grounds of
Yes,
appeal.
exactly.
Where it reads, the appellant who was then financially on his sister and a member of her household in Italy relocated with him as his sister's dependent.
Yes, my lady. So I accept it's not quite evidence, but I think it's great.
Well, as long as it's a finding, it doesn't really matter.
Well, I'm grateful. So can I?
Okay, we've got that.
Yeah, I'm sure my lords and lady do. And then, of course, we have the ultimate finding at paragraph 10, which I don't think I need to say more than note that in the middle, residence is facilitated before the end of the transition period in that he was admitted to the UK on that date under the regulation as evidenced by the stamp in his passport. And then we get the Article 10.2 finding that you've already heard substantial submissions on. And then there's the issue about proportionality under Article 18(1)(r).
Yeah.
Can I then turn, please, to what happened in the Upper Tribunal? And the decision starts at 138. And then you have the background at paragraph 3, and then that's at 139, and then paragraph 4. The claimant then had an Italian residence card on entry to the United Kingdom. His passport was stamped. That is not disputed. Makes the issue about the stamp. We then go, please, because I know a number of questions have been asked about how long the period of admission is either inferred or expressed. And I think the best we get is at paragraph 16, page 140. For the Secretary of State, Mr. Tuffan said that the Italian residence permit which the claimant possessed entitled him to enter the UK freely under EU free movement rules, but only for 3 months. He was required to regularise his residence in the UK after that, which he has not done. So it looks like the Upper Tribunal proceeded on the basis that he had a right of residence for 3 months, which appears to be the proposition which was advanced on behalf of the respondent, which is, of course, consistent to much of the discussion that has already taken place already. And unless I hear anything to the contrary, I'm going to assume that my learned friend accepts that that was how it was advanced below.
I can't speak to how it was advanced below. I accept it's recorded, but we said in our skeleton that if that was what was said, it's wrong. I'll deal with that. I can deal with it now. I can deal with it later.
Yeah.
Deal with it later.
Thank you. Can I reserve our position in relation to that specific point, because we do rely upon how the case would advance in the Upper Tribunal. Indeed, there may be an argument as to what period residence can be properly inferred from admission absent something specific. And that's probably something that my learned friend may need to address in relation to, if it wasn't 3 months, what period was it?
It is your position if it was A, entry alone, or admission alone, or B, entry and an initial right of residence for 3 months, that either or both of those would be sufficient to constitute facilitation within the purposes of Article 10.2.
Yes.
That's your position?
Yes. What we say is, and I hope I don't want to cut across an argument really that's really been covered at some length, but it is our submission, and I think we're absolutely on all fours with my learned friend's submissions already, that if the appellant's, Mr. Hasanaj's residence was facilitated, he falls within the scope of the withdrawal agreement, and it's conceptual as opposed to time determinative. So in other words, it essentially doesn't matter how long it is, as long as as long as there is facilitation, as long as the residence that comes with that requires facilitation. Of course, we recognise he does also need to apply, once he's here, for under the EU settlement scheme. So he still has to apply for it. But conceptually, we respectfully submit that the question is, is his residence facilitated under the withdrawal agreement? If so, he comes within that protection.
If you're wrong, and we're just testing all the hypotheses,
Of course.
and in fact you have to have more than 3 months residence, i.e. you have to have a residence card for 5 years, or permanent residence. What is your case then? That he had it, or he didn't have it, or is your case tied firmly to he had 3 months and that's enough?
I think we say, as I think we've heard already advanced, that he gets it is determined by the Immigration Act that gets him the right to admission and residence.
For how long? Forever?
I think conceptually it must follow that is what he gets. We don't submit that that doesn't mean he doesn't have a responsibility also to apply for residence under the settlement scheme once he's here. But conceptually, I think our case must be that once his residence is facilitated, he has the protection.
And he doesn't have to do the intermediate stage of residence card. He goes straight from I'm here forever, and now I want the pre-settlement status entitlement.
Yes, yes. We understand that that's, on one level, that could be said to be a bold submission. I accept that. But we do think, respectfully, that that's exactly what the implications are in relation to the submissions we make under what facilitation needs to be understood by if one comes within protection, as we respectfully submit under Article 10.2. Can I just complete the point as to what happened in the Upper Tribunal before I take to a couple of points in Alaraj that I would like to address you on. You can see the way that my learned junior, who did argue the case in the Upper Tribunal, argued it primarily in relation to paragraph, there was obviously a skeleton argument, paragraph 22, page 141, the submissions in relation to facilitation coming under the protection of the scheme of the withdrawal agreement. And paragraphs, I don't need to read it out to you, you can see that set out fully at paragraphs 22 and 23. And then, of course, there's the analysis, which is really set out at 24. And then, of course, Chelik at that stage had only been determined at the presidential level before the Court of Appeal, so I don't think you need to spend time on that. And then the ratio of the decision is set out at paragraphs 27 to 29. And really dealing with Lord Justice Lewis's point, there was obviously the decision was set aside because the contention that facilitation of residence is what is contained within the withdrawal agreement, limits to facilitation of entry. It doesn't look like the Upper Tribunal wrestled with the question about is there any residence period from which you can properly infer from the right of admission. It just simply doesn't seem to have been addressed. Paragraph 28 really deals more with issues of proportionality, which you're going to hear primarily dealt with by my learned friend de la Mare in due course. So that's how it was dealt with in the Upper Tribunal, and of course that I hope helps in terms of what the evidence was, what the submissions were, what the findings were, and I hope that's specific, obviously, to our client. Can I please ask the court to look at something contained within Alaraj that I think hopefully will help as to what can be reasonably assumed to be the questions that an immigration officer might well have asked. Because, of course, what we don't have is any evidence about what happened between the immigration officer and Mr. Hasanaj.
We don't have any evidence of what happened other than the stamping placed on the passport.
Exactly.
We don't have any evidence of what the immigration officer thought, other than objectively what he stamped the passport with. And more importantly, we don't have any evidence about A, what Mr. Hasanaj thought the stamp meant, or B, why he waited until, I forget, is it March 2021, before he made it?
September 2020.
September 2020, I think you can see that from...
Between March and September 2020, before he put in the application.
So I'm not.
Here we are.
According to the chronology, he made his
29th
first application 29th of
29th of June 2021. That's right. Yes.
So he had well, he couldn't have applied obviously before the middle of 2020, and that's when the sponsor was granted pre-settled
Yes,
status.
June 2020. That's right.
But then he basically didn't do anything himself for another month, for another year and a bit.
Yes. I mean, no one's suggesting, as in the case of Mr. Vasa, of course, that from his point of view, there's no suggestion, query what his actual status was. No one was suggesting he was misleading anyone. It was here.
Same. But the difference in Mr. Vasa's case, just to spell it out, is that there is evidence of what Mr. Vasa thought, or those advising him thought, because he did actually make an application twice, or once, as far as relevant.
Can you just remind me the date on which the EU scheme came into force? Because it came into force before the end of the implementation period. You can't criticise somebody for not applying under a scheme that isn't yet in existence.
Yes.
So do we know when?
Yes, March 2019.
March. Oh, so it came into force March 2019.
Yes. It was so that people could start applying sooner.
Yes, but it's right, isn't it? Just winding on through. He, in fact, couldn't have applied at that point because his sister hadn't got pre-settled status. He couldn't have applied with it.
He could have applied in principle. I'm just turning my back a moment. Sorry. He could have relied on her eligibility on the EU settlement.
He could have relied on her being eligible even
Yes,
if she hadn't
didn't
applied.
need to have
Oh,
it
well,
at
okay.
that. And the other point to mention, of course, is that he didn't, so far as an application under the 2016 regulations was concerned, she didn't need to have done anything or applied
No,
for
she-
anything.
yeah.
He could have done that at any point.
So he could have applied in March 2019. He could have applied at the same time as the sponsor applied in June 2020, or any time up until 6 months after the end of the transition period.
Yes. And in fact, late applications could be made. The difficulty for him, of course, was that once it was too late to apply under the 2016 regulations, it was too late for him to put the situation right, in the same way as it was for Mr. Vasa.
Yeah.
And when did that end? When,
So the extended family member application had to be made by the 31st of December 2020 because that's the deadline in Article 10.2. The deadline under the EU settlement scheme was the end of June 2021.
Yeah, that's probably no coincidence that he applied on the 29th of June.
Yes.
Yes.
So he is within the time, albeit at the very end.
But people are still making late applications
Yeah.
for the EU settlement scheme. They can do so if they've got reasonable grounds.
Yes.
he had to apply for a residence card by 11 p.m. on the 31st of
Yes.
December 2020, and he had to apply under the USS for pre-settled status by 31st of June 2021.
To be in time for the EU
Yeah.
settlement scheme.
I think I'll have to take a point against my client that he's only 1 day before the exam. It's only 30 days in
Or
June.
30 days in June, yeah.
But yes, that's exactly right. And of course, my lawyer is right. That I'm sure it is not coincidental that he applies on the 29th of June, but he's at least within the
Yes, of course, by that time he had the residence card problem.
Exactly. Can I just briefly ask you to look at the case of Alaraj? Now, we have to accept there are...
Just remind us where we'll find it.
Yes, it's 1301,
Which bundle?
tab 40 of the second bundle of the authority.
Right. You did say tab 40.
40.
40, that's it. Yeah.
And I think we have to accept, of course, it's a decision of the Upper Tribunal. It's greatest respect to the court. It's an impressive court sitting in the Upper Tribunal, and I say with some deference to the court that I think it may be necessary for the court to consider whether the case of Alaraj either needs to be distinguished or even possibly overturned in relation to this point. I heard my learned friend say that she's not asking for that. It's ultimately a matter for the court whether, to what extent, if the appellant's case is to be made out, appellant's plural case are to be made out, that the issues in Alaraj may need to be wrestled with and possibly considered again. I'm told by my learned friend very helpfully that there's an application for permission to appeal in Alaraj, which is being presently stayed pending, I imagine, this appeal. So the head note, the first head note to notice, of course, under the directive that you've been addressed about, the entry and residence of other or extended family members was to be facilitated by EU member states. Pursuant to that duty, member states were required to ensure that their national legislation contained criteria which enabled such persons to obtain a decision on their application for entry or residence, which was founded on an extensive examination of their personal circumstances. Now, I say at the outset that really the point is obviously very clear already. We simply don't know at the moment whether there was an extensive examination of the circumstances in relation to the appellant. We just don't know that evidence.
It doesn't really matter, does it?
It doesn't matter now.
But it never mattered. It's only a point for your protection.
Yes.
It's not a point the Secretary of State can say, this isn't valid because I didn't do a
Yes, but depending on the outcome of the case, it could have some relevance in relation to further down the line as to the best way, the fairest and best way to proceed in relation to the case, because of the issues which would require potentially examination and consideration of evidentially further down the line. But I of course accept, my Lord, that it doesn't matter for the primary matter that needs determination by this court. And then you'll see at the head note at 4 and 5, it's really the ratio in the decision. A person who claimed to be an extended family member to whom Regulation 7.3 did not apply could not be lawfully admitted by an immigration officer under the regulations. And then 5, a stamp applied in such circumstances of no legal effect in an appeal under the 2020 regulations, neither a family permit nor residence card, not a relevant document, and not evidence that the person's residence was facilitated for the purposes either of Articles 10.2 or 10.3 of the withdrawal agreement. And that's why I think I have to face up to the fact that this is a decision which is factually and evidentially of some similarity to the present case. I would say this to assist in relation to information as to what would happen. Covered in the background. Now, you were taken to, I think, Mr. Vasa's, I think it's paragraph 36 of Mr. Vasa's, I think it was the submission. Upper Tribunal decision in Mr. Vasa's case. We can go back to, if necessary, the questions that were asked in relation to Mr. Vasa's case. Now, I, of course, accept I can't advance what was actually the conversation between the immigration officer. But you heard already taken to what Mr. Vasa's case was. Perhaps more interestingly, or at least more generally, it might be useful to see what happened in Mr. Alaraj's case. And you can see that it really starts at paragraph 7 and 8, which give you some...
Just give us a moment to read
Of
it,
course.
and then you tell us what submissions you
Can I
made.
ask my Lord to read paragraph 5 as well? It'll save me coming back.
Oh yes, I was going to... I could see
Yes,
it
I hadn't, I'm afraid, focused on Alaraj until now. And even without paragraph 5, I began to think 2 might be coincidence, but 3... Yeah.
Yeah. No, I'm grateful.
Okay.
I would have probably have gone back to it anyway, but I'm grateful.
No, well, let's just read. Well,
Yeah, of course.
We'll read 5.
Probably 5 through to 8 inclusive.
Yeah, thank you. Yes.
Two observations, please.
It's interesting, before you start, is Mr. Della, the presenting officer himself, who described the stamp as regularly encountered, the use of which is shrouded in mystery.
Yes.
You think the Secretary of State might know the answer to the mystery? But
They might. Can I ask, since that point is now being raised, my Lord, also to have a look at paragraph 17 on the next page, 1305.
16.
I can see there's a mark on 16. So again, can I ask for 16, particularly 17 for the purposes
well,
of this?
we'll read both.
Thank you.
And remind me what McCarthy decided?
I'm sorry, my Lord. What was the decision?
Well, Mr. Della, who obviously had made some inquiries with his clients, said that the stamp was created to deal with the McCarthy situation. And I just wanted to be reminded, polite way of saying told, what McCarthy decided.
Oh, McCarthy. I think McCarthy is contained within that, in the bundle. Just give me one moment.
Well, don't worry. Just tell us in a word. What was the? Oh, Mr. Delamere wants to do it.
It decided that if you already had an EEA residence card, you were effectively exempt from visa control, and you couldn't be required to produce effectively a family permit again. You could just present your EEA residence
Yes, I see.
card. It was
Okay.
a fast track.
We have it in the bundle, but I hadn't read it.
I don't think it is in the bundle.
Oh.
It's discussed in the case of court, but to be clear, it's not any family member, it's a direct family member with
Yeah.
a direct right to entry, so it doesn't help extend to family members.
No. Okay, but it's just helpful background to know.
That's what
Okay.
it's about. As I'm
Thank you.
on my feet,
Yes.
there hasn't been a chance to pass this across. Out of fairness to Mr. Della, could the court please also read paragraph 15.6, where he was very clear about what the proper use of the stamp was.
Yes, I was going to do that. I did get that
Yes.
message, but of course.
Yes.
15.6, I think, and great respect to Mr. Della, I think he may be in the court building. So, yes, of course.
So it looks. May as well get this out now. It looks. There's no reason to doubt Mr. Della's explanation. It looks as though it was created for a rather limited and specific purpose, whether by accident or because they had been given misleading guidance as to its real purpose. Many immigration officers were using it in circumstances other than that for which it was initially devised. I'm just saying that generally,
Yes.
so that
And my Lord, I think it was my Lord, asked my learned friend about, do we know how many cases there are? Clearly,
no, I did, yes.
And Mr. Allard is obviously another example.
No, I know. Well, sorry, we've been over this the last 5 minutes. Yeah.
But and it has been a subject of I think of an express request as to how many cases. I think my learned friend, as the intervener, made an
They
application.
said they didn't have the data.
We made an FOI.
There's an FOI request that I think remains unanswered.
Oh, sorry, there's somewhere Ms. Smythe says we haven't got the data. We don't know how many people have benefited from the use of the stamp.
Yes. So I think I can't advance the point too strongly, but to suggest that there is probably quite a number of similar cases for the reasons really that appear apparent from the decision in Alaraj as the rationale.
I don't think it really matters. The point is, and I think I probably should have picked this up if I'd read the sentence properly beforehand, but that it is now clear that this is not two one-off cases.
Yes.
Because Alaraj is a third, but more importantly, in Alaraj the court was told, the tribunal was told that there were several others.
Yes.
And it didn't really, for that point, doesn't matter whether it's dozens or hundreds.
It perhaps doesn't matter. It might be of some, albeit tangential, relevance to know, to understand why perhaps the Secretary of State is pursuing these cases, because there are potentially implications for quite a large number of cases.
At the moment, I don't see why it's relevant, but anyway, there we are.
Well, it's only because I
I
think
know
it
I've
got
asked,
raised.
but even all the same.
But I think really the 2 points that I would really want to glean from this part of Alarage that we've looked at. First of all, the really powerful, if I may say, criticism of what has happened to people such as Mr. Alarage, and indeed such as Mr. Hasanaj, in relation to what's described in Alarage as a most unsatisfactory state of affairs, characterised, and really this is my own friend's points in relation to 10.3, a lack of legal certainty and a anathema to the orderly system of immigration control. That's strong language. And the other point really I wanted to advance is that although we don't know in Mr. Hasanaj's case what happened between the immigration officer and himself, or indeed his sister, we don't have that evidence. What we do have is an example of the sort of material that would be asked. Now, I accept that's not evidence, but it does perhaps give a flavour. One can assume it's not just simply, if I use the expression, just a simple rubber stamping of here's your stamp. We can't advance it more than to say that seems unlikely.
Well, we just don't know. It may have been, this case, he was obviously taken into a room by an investigation officer and asked quite a lot of questions. We have no idea whether the same was true in the other two, in your case or in Vasa.
Well, we know a little bit from Mr. Vasa from that paragraph 36 of the Upper Tribunal.
This chap would have been on the Home Office computer anyway, because he'd applied for asylum and been refused, and they would have been looking out for him, or they'd have done a name check. Mr. Hasanaj came with his sister and 2 nieces, and all we know is that the man downstairs, or the woman officer downstairs, saw a man, a woman, and 2 children with them and let them in.
Yes,
That's all we actually
my lord, I of course accept. I can't gainsay that. I'm trying to help in terms of the sort of material which might have been available.
We can see what happened in this case is the most that could be said.
I agree. I'm not going to.
Okay, let's carry on.
So, my lord, and really the last point, which I think you have in relation to paragraph 17, which is really the point of if one can see there. I think my lords have it in relation to the sort of position that it was in relation to the question. I think it may tie in on the question of dependency or households, the way that paragraph 17, Mr. Deller has dealt with that paragraph. But I shan't take that point any further than that. So that really sets out, if I hope I have set out the factual position historically in relation to Mr. Hasanaj's case. We have sought to assist the court in relation to what was available in the case of Alarage. I have to, really, I think I do have to say that, with the greatest of respect to the court, that this court will have to look at whether Alarage was correctly decided or not. Yes, and I don't want to repeat myself anymore in relation to that. As far as wider submissions are concerned, can I reserve my position in relation to the case of Sadiqa? I don't think I will have any specific submissions. I don't know yet how my learned friend is going to deal with that case, but it may be, if I can reserve our position in relation to Sadiqa, we will respectfully submit that there's a very big difference in relation to Sadiqa case, the present one, in relation to the question of what Mr. Hasanaj's position was on the question of facilitation. My lords, my lady, you will hear very shortly in relation to the submissions in relation to Article 10.3, which we respectfully will adopt, although my learned friend will address you. And if there's anything that comes in the course of his submissions that
Yeah, but you've said that as well.
I'm getting a very strong judicial hint.
I'm very happy to hear more, but you've already told us that you're going to adopt
Yes.
Mr. Delamere on 10.3.
My lord, in relation to Article 10.2 in our respectful submission, we have the same submissions in relation to those. We respectfully submit that the primary submission is that was facilitation under Article 10.2, which brings the appellant within the withdrawal agreement, and we have the alternative submissions in relation to 10.3 on the question of disproportionality, lack of legal certainty, and the other aspects of Article 10.3 that we respectfully submit we also come within as an alternative argument if Article 10.2 does not prevail in relation to our submissions that the mistaken actions of the immigration officer mean that he can't avail himself under Article 10.2. I'll just check there's nothing I've missed. My lords, my lady, that's all my submissions.
Thank you, Mr. Spencer.
Thank you, my lord.
My lords, my lady. Secretary of State wants to say that because the stamps in these cases were erroneous, not only can they not amount to Article 10.2 facilitation, that means the grant of a family permit, but they're devoid of all relevant legal effect. Now that talk of erroneousness is a euphemism. The true position is made far more clear in the case of Araraj, you've just been looking at, where the Secretary of State was explicit that what he was saying was that there was no violence under the EEA regulations for anyone other than an entry clearance officer to grant anything other than a family permit, and only after the requisite form, the EEA EFM, Extended Family Member Form, had been fully completed so as to comply with Regulation 21. It was only in relation to such an application that there was varies to do anything in relation to non-EEA visa national to permit them to come into the country, and anything else is unlawful. And that's the Secretary of State's case as to the unlawfulness of the stamps. And I take as a predicate for my submissions, obviously I accept and endorse everything my learned friend said about the Immigration Act. My submissions are predicated on that argument failing, and the circumstance being one in which the stamps are on their face ultra vires. Now we accept that if the stamps were ultra vires, then subject to my Lord Justice Lewis's point about an unchallenged act, there can be no legitimate expectation that that which was promised in the stamp will be delivered if it was promised to be facilitation. And that's because it's both a feature of our domestic law and of relevant EU administrative law that you can't fashion a substantive benefit from an ultra vires representation. So we think the question posed by the Secretary of State's primary case, namely that the stamps are unlawful, is this: what is the legal significance of that conduct, given its evident propensity to mislead and its evident propensity to cause unfairness, for the cohort, and I use that word advisedly, the cohort of people receiving such stamps, evidently relying upon them. And if you wanted evidence of reliance, look no further than how the cases have been formulated before the tribunals before this day. And having made, and this is the critical point, having made what were in substance, even if non-compliant with the procedural requirements of Regulation 21, requests for facilitation. Because what else is it if you turn up at the border with your EEA national sister or brother, father, and say, I want to be admitted because I'm part of their household, I'm one of their dependents? What is that, other than in substance a request for facilitation?
Well, a request to be admitted.
Well, admitted. We'll come back to that point, my lord, as to whether or not there is a distinction.
You asked your rhetorical questions you didn't want us to answer.
I thought it was a genuine question.
Touche. We say there is no distinction to be drawn from the notion of admission. And the types of distinction my learned friend seeks to draw actually have no support at all. Not least because whether it's under the 1971 Act, if you're granted leave to enter, you're granted permission to reside, effectively, consistent with the terms and conditions of your leave. That's why, for instance, in the field of benefits, where I spend far too much time, the manner of control over access to the social security system is the imposition of an NRPF condition.
Well, why are we talking about the 1971 Act?
Well, that's my learned friend, Miss Sandwich's case, that permission has been granted under the 1971 Act. If it has, then it follows there is permission to reside, so far as it's consistent with the terms of entry.
I thought you were proceeding on the assumption that that wasn't right.
I'm proceeding on the basis that whatever has happened, there hasn't been an intra vires decision on the basis of the application that was made. So one postulate is Immigration Act, and I'm simply making the point that if you're granted leave under the Immigration Act, you're also granted permission to reside consistent with that leave. If you're granted a family permit, you will see when we come to the regulations, there is no obligation under the regulations themselves to convert that into a residence card. That's highly significant in the structure of the regulations. So, because facilitation under Article 3.2 is a discretionary decision under national law, it's not a system of declaration of directly effective rights, it's a constitutive system. Our case addresses the alternative, which is that there was no valid or binding decision on the application that had been made. So what then happens? What's the significance of the stamps? And our case is that the stamps are evidence of the fact that Mr. Hasanaj and others like him made a practical request to someone in authority or appearing to be in authority to facilitate, which request, and this is the critical point, has been left unresolved as a result of the unlawful decision. And the critical thing, therefore, in the case of Mr. Hasanaj, is that request was made back in March 2019, which predates IP completion day, and therefore is, if not marred by procedural defects, a qualifying request for facilitation for the purposes of Article 10.3. It means he's within the material scope of Article 10.3. We, of course, accept he didn't comply with the national procedural requirements under the EA regulations. But critically, and this is a function, a direct function of the practice or policy in play, he was never told that. Instead, he was faced with official conduct that effectively must have led him to believe that his request to enter and thereafter to live with his sister had been granted. And that's what led then to him praying in aid the stamps when he came to make his EUSS application.
Hang on 1 second.
Now the content...
Wait, no,
I'm so sorry.
Now, I don't want to put you in an invidious position of supporting one appeal but not the other, but I think I've got to ask, what you've just said about Mr. Hasanaj's position would distinguish it from that of Mr. Vasa.
Well, the distinguishing feature of Mr. Vasa's case relative to Mr. Hasanaj's case is the fact that he made an application once and then made a second application.
And more specifically, he made an application, and in response to that, he was told what he could do to rectify his position.
That is the distinguishing feature. That is why our submissions are concentrated on Mr. Hasanaj's case. I have already had this argument with my Lord Justice Lewis once in Chellick, and I don't intend to have it again. The difference between the two cases is that the Vasa case has some of the same features as Chellick, and the Hasanaj case does not. And the point is, from the perspective of Mr. Hasanaj, is that the reliance, therefore, on Regulation 21 operates as a cliff edge, because by the time he's told his application is defective, because he doesn't have a relevant document, he hasn't applied for a residence card, we're after IP completion day, and he has no means, effectively, to make an application.
I'm still slightly confused, actually. Just help me with this. You began by saying there's no binding. The human state of the world, there's an application for something.
Yes.
And you called this, presenting yourself at Stansted Airport, an application for facilitation. That's what you called it.
Yes.
You say there's been, on the Secretary of State's own case, and she may be wrong on this, but on the Secretary of State's own case, that request for facilitation has not been dealt with.
Correct.
So I thought that you were then saying, right, there's an undetermined application for facilitation.
Correct.
And he then, well, I don't know what he did in March 2021, because he's already made his request for facilitation.
You mean June June 2020.
June 2021, he's pre-denied what he thought was the grant of facilitation. So it's obvious he presented it as a 10-2 case, but it is in fact a 10-3 case.
But hang on, so you're saying that it seems to me that that's switching in and saying not that there was an undetermined application for facilitation, as you called it.
Yes.
There was a determined application, because what they determined to do was a number of things. They physically allowed him through the passport barriers, and they stamped his passport. He wouldn't have been in England unless they let him in.
Yes, but the question is, does that constitute a relevant document? That's really the test to which we actually ultimately have to point. And what is a relevant document for the purposes of the EUSS? That's one of the reasons why all of these cases have the features that they do in terms of the relative evidential paucity before the First Tier Tribunal.
My problem, I thought the fact that there hadn't been a determination of an application meant that there was an outstanding application which had to be resolved.
That's correct.
But as I then listened to your next sentence, and you seem to be saying something different, that which happened in March 2019, the putting of the stamps and the physical allowing in, is in some way an acceptance of residence, which meant he had to get.
No, I don't say that.
I understood you to say, so I'm not
Yeah.
I understood you to say that what he did in June 2021, thinking wrongly that the grant of entry and the stamping of the passport was a resolution of his application for facilitation, he then applied for EU settled status or pre-settled status.
Right.
But he was in fact wrong about that, because it wasn't. It was.
There was no binding decision, and therefore there was.
Well, what do you mean by binding? Why wasn't it binding? Because the Secretary of State says it wasn't.
It was ultra vires, the decision. The Secretary of State. What's the peculiarity of this case is that the Secretary of State is the one who is praying in aid the ultra vires, the nature of the decision.
Yes.
And yet, I'm so sorry.
So I'm still wondering then, so what's left for the Secretary of State? You want mandamus to tell the Secretary of State to go and decide my application for facilitation, is it?
Absolutely. What we say, the proper thing that should happen in cases such as these, because we don't advance a case of substantive legitimate expectation. We don't say the relevant question has already been determined. We say the correct thing that should happen in these cases is that they should be considered on their merits as to whether or not the extended family member test was met under the old regulations, such that they could have been granted a family permit and could now be granted a letter reflecting the fact that they were entitled to a family permit. Now, you looked earlier today at the definition of the relevant document.
So how do you decide if you met the criteria for the grant of the family permit, because that's in effect what they were asking for when they turned up at the airport.
Absolutely.
And what they must now decide to do is grant a family permit. Well, that's gone, but we've got all those guidance saying they'll issue a letter instead.
Exactly.
So you're saying you just want the position frozen as at when they went to the airport. And what they should have said is, well, they should have told them to go away and come back when they got a family permit. But what you're saying is they said, well, we'll deal with that application at some stage, and they still haven't done it. You come and wait in England whilst we deal with it, and we're now dealing with it, and you're saying you must make them determine that application at the airport as if it were a valid in-time application for a family permit.
We say it was.
No, is that
is it. Yes, that is
Hold on
it.
a second then.
So, page 4.
Wait.
I'm so sorry.
The Lord wants to write down your answer.
Page 489 defines a relevant document. And it's a family permit.
Wait.
we did look at this particular bit I'm about to emphasise in Chelic as well. A family permit, brackets, or a letter from the Secretary of State issued after the 30th of June 2021. That's the date in which the EEA regulations are repealed, confirming their qualification for one. So what there is a facility to deal with outstanding requests that are made in time by way of letter.
Yeah, I understand that, but your essential point is that presenting yourself at Stansted Airport on the 19th of March, whatever day it was, 2019, that by presenting yourself, you should treat that, whatever the procedural was, as an application for a family permit that hasn't been granted, and they should crack on and grant it or grant the letter and equivalent.
In circumstances where the grant of the stamp causes the unfairness that it does.
But that's what you're saying the position is.
That is our position.
So the presentation at the airport equals an application for a family permit.
It's an application to be considered for facilitation
Yes,
as an extended family member. That's what it is.
Yes, which
Within the scope
square
of
brackets, which in our domestic system we call a family permit under the EUSS, or indeed.
Absolutely, my lord. But even more
But the essence of it is that it's a request for facilitation in the case of an extended family member.
even more
Facilitation of
precise.
entry and residence, which in our case is done in stages, family permit, residence card, and then EUS pre-settled and settled. Yeah.
Even more precisely, and it is important to be precise, it's an application that falls within the scope of Article 10.3 of the withdrawal agreement, that falls within the scope of Article 3.2 of the CRD. And the reason for that is that we say, whilst national law provisions do indeed shape facilitation, they don't do so in a way utterly unbounded by EU law. We know that from the Raymond and Banger cases, which explain what facilitation means, and it's a concept of EU law. We know it because general principles of law must ultimately control the operation of the national provisions. You couldn't have a national scheme for extended family members that was discriminatory on grounds of nationality or sex or race. So EU law still has a controlling role, even though it's a role principally discharged by national, procedural or substantive policy choices.
Would there be a problem in requiring first a family permit and then a residence card? I understand your arguments about here, if you have a problem when they don't remind you that you need a family card and they let you in and you get stuck further down the pipeline, there's a problem. But essentially, is having a requirement of a family permit...
In principle, no.
Okay.
This goes back to the debate, again, I had with my lord in Chelic, which is, when you start looking at Regulation 21, it was a regulation designed in 2016 for a very different world and a very different purpose. It was designed for a world where there were no cliff edges, and where if your form was non-compliant, you're kept out of the country, your simple expedient was simply to reapply. There was no one-time shop. There was no catastrophic loss of rights of the kind that occurs with Brexit. And the vice of the 2016 regulations is the elevation of that procedural requirement in conjunction with the provisions of the withdrawal agreement, because it creates an utterly disproportionate cliff edge. That's the vice that's
in the
this
past,
case.
if they got it wrong, you say, don't worry, do the form again. But we've left now.
Yes.
And they can't.
Exactly so. Now, there are a number of provisions of both the withdrawal agreement and of the Citizens'
Just
Rights
before we get on to that, I just want to think something through. Give me a moment. But it's an important part of your submission, a necessary part of your submissions, that he wasn't told of the need to make a separate application if he wants to reside for more than 3 months.
Absolutely.
Otherwise, your answer to my lord's question that there's nothing wrong in principle in facilitating entry and longer-term residence separately would be fatal to your case, because in that case, all that would have been facilitated would have been entry. But you have to say it's unfair to facilitate entry and not longer term residents, unless you make clear what the necessary next step is. Have I got that right?
That's in part right, but it's also important to realise, and I'll show you this by reference to the 2016 regulations, there was nothing in the structure of the 2016 regulations that actually required you to convert a family permit into a residence permit. There was no requirement to do so under the 2016 regulations.
But you wouldn't have a right of residence afterwards.
But you may not be concerned about that if you're a child. Or
Yeah. But one of the things that has occurred to me, I don't think I've ever seen an EEA family permit. I don't know whether you get one. It says in big bold letters on the front, care here, don't trust us, we're British. You must put in another form within 3 months. I just don't know what anyone
I've looked at samples. It doesn't say anything about conversion.
What does it do then? Does it say anything about the time?
What's more, they do, as a matter of policy, state the duration of the permit. And as a matter of policy, I know my learned friend is nodding, the policy is to grant such permits for 6 months. But there is nothing in the regulations that requires either a time period to be set or the time period to be 6 months.
You've got to apply, you've got to come in 6 months, I think. It's only valid.
It has to be that you're intending to travel within 6 months of the application. That's Article.
So if you get a family permit, unlike your stamp in the passport Mr. Hasanaj's case, you will see that it's got 6 months on it, and you'll know you've got to do something after 6 months.
If you are the recipient of a family permit, yes, but obviously that doesn't apply in Mr. Hasanaj's case.
No, exactly, that's your point though.
Absolutely.
The unfairness is, if you get your family permit, or if you get your letter in Mr. Vasa's case, you know that something's got to happen. But you're saying he was quite happily looking after his sister and the 2 nieces, and when he finally got round to putting in his form, suddenly, for the first time, he discovered that it wasn't enough to rely on the stamp of the passport. You're saying the unfairness comes from the combination of he's been given something to allow him to be here, but he's not told that it's for initial residence period.
Absolutely so, my lord. And of course, it's important to understand what the purpose is of a duration in a family permit. It's to permit you to come and go in the relevant period. If you don't need to come and go, you don't need to extend your family permit at all. You don't intend to travel. It has no bearing thereafter. And one of the peculiarities, and it is a sort of historical curiosity, there was this category of persons called the lawfully present, who arrive perfectly lawfully for whatever reason. They don't require entry clearance for whatever reason, but they may not have an extended right of residence under Article 7, etc., the direction, because they're there often not working, or a family member is working. And unlike many civilian jurisdictions, we don't care about that unless and until you claim benefits, because we're not interested in policing the people who have a right of residence within the country. We only police the terms of your immigration mission.
We've got here that we've got no idea at all about what Mr. Hasanaj actually thought or believed. We just don't know. That's the first point.
Yes.
And secondly, if we're down to inferring or making objective determinations, all that anyone knows, having come through the airport, is they've got a stamp in their passport saying admitted.
Well, you may have detected some interest on my part in the contents of Allarage. I do say a number of things. So one of my learned friends' points against me is, well, you haven't got any facts to substantiate this. We don't know what the position is on the ground. We don't know what the background is. The first thing to note, of which I invite you to take judicial notice, is that immigration officers at the border don't wave visa nationals through and simply stamp their passport without any attention at all. Visa nationals, on presenting a visa national passport, are invariably subject to questioning to work out why it is that they don't have a visa. The reason they're called a visa national is they're required to have a visa. So if you don't have a visa and you're a visa national, you better have some pretty darn good reason for coming into the country or suggesting you is. Next point. What inevitably, therefore, must have happened, unless there was a total dereliction of duty by the immigration officers, is that there must have been some investigation into the facts and circumstances of these visa nationals presenting themselves without visas to work out why it is that they should exceptionally be allowed into the country. And the only rational inference to make on the facts of these cases, given the nature of the stamp and given what little we know of the practice, is that what happened is that the immigration officers asked questions to establish whether or not someone in question was as they claimed.
Sorry, you're competing with whatever is going on outside.
Yes, not sure you can talk much louder, Mr. You already do, Mr. Delamet.
What shall I do?
No, before I give stop now, let's just go back to the immigration officer asked questions to establish.
To establish whether or not the person in substance was an extended family member. So if you go back to Alaraj, you will see that Mr. Alaraj's contention was that he was in a durable partnership. That's one of the categories of extended family members. It's 3.2b as opposed to 3.2a. And all of the questions that he was asked, having been detained, and his fiancée, who was an EEA national, were directed at establishing that they had a genuine relationship. So that's the kind of questioning that must have occurred in all of these cases of visa nationals.
In Mr. Vasa's case, it would probably have been quite easy, because as soon as you discover he's 16, he's going to be dependent on somebody. They might have been a bit surprised that he was dependent on his brother or his father, and they might actually not have bothered too much about which it was.
Absolutely. Once the household is established and who the breadwinner is for the household and his dependency within it, then the point becomes clear. But the idea that any of these people would have been admitted without that form of inquiry is unreal.
That's why I think you might have another problem, because I haven't yet accepted Miss Mai's beguiling argument that it would only be in cases where you had a family permit that you should be treated as a family member. Family members can get entry into Regulation 11, I think.
Well,
That's the first question. And you only know that a family member doesn't include the dependent brother or the dependent...
I look forward to that exchange. But
If they meet the criteria, it may not be unlawful to you must treat them once they've got the permit, and wonder whether they have to be treated.
I suspect,
Something that otherwise.
as was in fact in part the case in Underhill, and as was our discussion in Chenek, in part the problem is Regulation 21, which prescribes how you must apply for entry clearance and how it is you must go about to establish. It said that if you don't follow that procedure, you can't ever satisfy the relevant entry clearance officer, you can't be an immigration officer, and therefore the whole thing is ultra-valid. So I suspect that might be part of my learned friend's answer. To which my answer is, we don't care. That's a procedural requirement of national law, which ultimately is controlled by EU law general principles of good administration and proportionality, and we would add, for good measure, controlled by good old-fashioned common law conceptions of fairness when it leads to a conspicuous unfairness. We're not asking for a substantive benefit. We simply ask for this case to be considered on its substantive merits.
The problem that you've got is, underlying all your submissions so far, and that's what I was checking, is that what exists is an application, which we call an application for facilitation, which needs to be determined.
Yes.
And the reason why it hasn't been determined yet is because you accept the Secretary's argument that the immigration officer acted unlawfully. And I'm saying, one, I don't necessarily accept Mr. Mai's argument yet, and two, I don't care at one level whether he acted unlawfully or not. Once a decision is taken, that is lawful and produces legal effects until it's quashed. And then you're into the question of, if somebody is granted admission under Regulation 11, what then is the consequence?
Well, we say, and that, I think if my Lord goes down that path, then we say, my learned friends win effectively under Article 10.2, because it is a grant of something that's a right to enter and reside that's facilitating extended family members. It can only
it's got to be residence for Article 10.2, and it's got to be residence facilitated thereafter. The question then is whether a 3-month residence is what is driving at, or whether it's residence beyond that.
I'm conscious of my Lord's point, but before I answer that, I would like to show you some of the legal provisions, because the position is, I'm afraid, considerably more murky than one would hope it would be, because of the non-correspondence between the Citizens' Rights Directive and the regulations, which makes for all manner of unnecessary complication. But can I just show you a couple of provisions of the withdrawal agreement first? I know that you've pored over Article 10. Of course, the critical thing for present purposes in terms of interpreting Article 10 is Article 4, the methods and principles of interpretation. And given the time, I'm not going to take you through Lord Justice Green's judgment in the case of AT, but he gives an absolutely compendious and I suggest excellent account of how it all works, and in particular, how in consequence of Articles 2 and 4, both the Charter and all the usual roster of EU law general principles are both aids to interpretation and controlling principles for the operation of the withdrawal agreement.
You say given the time. In fact, I don't think we have AT in our bundle.
It is in the bundle. It's,
Is it?
Tab 39, I think. It's the Secretary of State for Work and Pensions against AT.
It's tab 42. Thank you.
42.
I haven't noticed it. Yes, thank you.
And it's round about paragraphs 80 and following that are particularly useful for the general
Yes,
principle.
thank you.
The critical thing to note about Article 10 is that 10.1, A to D, and E and F create a test of pure personal scope. The substantive rights that are conferred when you meet the test of personal scope are those conferred by Article 13. And AT is the case that fell in that bracket. The peculiarity of Articles 10.2 through to 10.5 is it's both combined personal scope and grant of right. Because what they effectively say is if you've already been facilitated, you retain the right as facilitated. If you have applied for facilitation and in due course facilitation is granted even after IP completion day, then you retain that right. The critical thing to understand then is what the purpose of the EU settlement scheme is, and its principal purpose is to discharge Article 80, page 28. This is not a means by which you obtain a right to residence for the first time. That's what is necessary or principal function. Its principal function is to operate as the new constitutive system of rights as we move away from declaratory EU law rights to constitutive national law rights as the withdrawal agreement permits. And so that means what you have to do in a typical case is convert your directly effective right, which existed on a declaratory basis, and say, I now want the constitutive right as reflected by the EU settlement scheme. Now again, because it's Brexit, it's never quite that simple. The scheme, the EU settlement scheme, in a number of respects, was more generous than the ambit of extant EU rights. One area where it was more generous was in relation to the lawfully present, i.e. those who had entered lawfully but didn't have a right to reside. But that's the basic function.
Somebody had the right to permanent residence. The French had the right to permanent residence before the implementation period. They continue to have a right to permanent residence thereafter. If they had a right of 5 years residence building up thereafter to permanent residence, that's what's transferred over.
Correct.
So whatever Mr. Hasanaj had on the 19th of March 2019, when it's finally facilitated, if it is facilitated, that right will carry over.
Correct. And all of that is explained very clearly in Lord Justice Green's decision in A2. Then what you haven't been shown is Article 21, 38. This is a straightforward, in the jargon, renvoi. The safeguards set out in Article 15 and Chapter 6 of the CRD shall apply in respect of what? Any decision by the host state that restricts residence rights of the persons referred to in Article 10 of this agreement. So it bites on 10.2 and 10.3 as well. And that's because the function of the CRD, Chapter 6, is to provide a series of procedural safeguards about how decisions on those topics are reached. So that's the withdrawal agreement. CRD, the next tab. There's a couple of provisions here that I need just to briefly talk you through. You've obviously seen the definitions of family member and the wider Article 3.2 stuff. I'm not going to go through that again. If you look at rights of entry at 95, Article 5, this is the genesis of the family permit system, because the CRD makes a distinction between EEA nationals who are not subject to a requirement
who can't be subject to a visa requirement, and family members who are not nationals of a member state, 5.2, who can be. And the family permit process is effectively that visa process for those who are not nationals of an EEA member state. Then over the page, Article 6, this is one of the nuances, the right of residence for 3 months is conferred only on 2 cohorts of people, union citizens, 6.1, and family members of union citizens. And under the scheme of the directive, family members does not generally encompass extended family members. So there is no right of residence conferred by Article 6 on extended family members. It is conferred as a matter of national law by the way that we have chosen to implement. So it's an area where the 2016 regulations goes beyond the directive. And that's the case of Bangville.
That follows because they don't have rights under EU, other than the right to be facilitated.
Absolutely. It's important to understand that, because that actually does have some bearing on the question of what the stamp signified, and it must have signified an intention to grant a right of residence as well. Then Article 7 is the extended right of residence for those who are workers, self-employed, have sufficient resources, etc. But can I ask you in particular then to look at Articles 9 and 10? And I confess the fault is mine. We didn't focus sufficiently in our written submissions on 9.3. It's an important provision. Article 9.1 says, member states shall issue a residence card to family members of a union citizen who are not nationals of a member state, where the planned period of residence is for more than 3 months.
You read from what?
9.1, page 101.
9.1, no.
The deadline for submitting the residence card application may not be less than 3 months from the date of arrival. That's to tie in with the 3-month entitlement provided for by Article 6. So if you're exercising your right of residence in that period, you can't be required to seek a residence card. And then this provision, under the heading of something, administrative formalities for family members who are not nationals of a member state, failure to comply with the requirement to apply for a residence card may make the person concerned liable to proportionate and non-discriminatory sanctions. Now, if there's any traction in my learned friend's case that the vice here is the failure to turn the stamp or family permit analogue into a residence card, it must be governed by 9.3 and by considerations of whether or not the sanction in question is proportionate and non-discriminatory. So it's a clear textual pointer to the fact that proportionality operates to control decisions of the kind we're faced with. And then Article 10 deals with the issuance of residence cards. And after that, unless I'm asked to show you anything else,
Sorry, I'm just thinking about 9.3. Sensible. I mean, whoever wins, you would say it doesn't matter because that trumps it. Say we don't accept Miss Smythe and we think it's perfectly lawful. If it wasn't lawful, I thought she should have challenged it. And there was the grant of admission. And then I would say, well, they've still got admission as residents for 3 months, but that's not enough because they want 10 free residents for longer. You would say that's when 9.3 applies because if they haven't got it, what they shouldn't have done is refuse anything to Mr. Hasanaj. They should have said, look, you should have got your residence card in, but in fact you meet the substance of it, and therefore we'll fine you, we'll write you a very stiff letter saying you really mustn't do this again, in English and Italian, but what they can't do is say, and that which is yours, your right to live in the house that you're a part of,
you have lost
is going to be taken away forever. That's what you say there.
Correct.
So even if we're against Mr. Smythe all the way down the line, Mrs. Smythe, all the way down the line, you still say 9.3.
Correct.
Yeah, okay.
Article 15, which was the first of the provisions in the renvoi in Article 21 of the withdrawal agreement, The procedures provided by Articles 30 and 31 shall apply by analogy to all decisions restricting free movement of citizens, their family members, on grounds other than public policy, public security, or public health. And there's CJ law case law confirming its extension to extended family members. And then you go on to 31, the procedural safeguards. The relevant text of 31 starts at page 121, and the passage we rely on is 31.3. The redress procedures, that's the tribunal system for our purposes, shall allow for an examination of the legality of the decision, as well as the facts and circumstances on which the proposed measure is based. They shall ensure that the decision is not disproportionate, and then particularly in view of the requirements laid down in Article 28, which don't apply in present circumstances. But there is a requirement to ensure that the decision is not disproportionate. So you have the clearest of textual pointers from the withdrawal agreement read together with the provisions of the CRD, even before you get to AT and the general principles applying generally, that this is an area where the principle of proportionality controls.
What I'm now puzzled about is this 9.3 and all these other requirements that says even if they haven't applied for a residence card, the consequence can't be refusal of their underlying ability to be with their family members. It's got to be something less. Why aren't you going into bat for Mr. Vasa then? Why isn't he in the same position?
Because ultimately I pick my fights. I don't want to have a fight with my lord about Chelik all over again. It may well be that that's a fantastic answer for Mr. Vasa as well. But
You're not making it.
But I don't need to, because I just need to address the one case in which I can be sure that I don't have that additional baggage to address as well. It's as simple as that. I'm trying to conduct an intervention in the time I've been given.
But the additional baggage in Mr. Vasa's case is simply that he was given the opportunity to regularise his position, tell what he needed to do.
Correct.
But you are, I think, acknowledging that on a rather stronger application of the principles in 9.3, it could be said to be a disproportionate sanction, even in those circumstances, to send him back age 18
I
to...
think it's a compelling case. It's disproportionate in Mr. Vasa's case, but it's unanswerable in Mr. Hasanaj's case, because what else could he have done? Because by the time he was actually told the stamp wasn't what he thought it was, IP completion day had gone and he couldn't remake the application. The cliff edge was unavoidable.
I appreciate that. The problem is there's the additional disproportionate factor, you say, that he can't now save the situation because
Correct.
he's left.
And that's a
fact. From your point of view, I don't see why Mr. Vasa is necessarily in a different position. Here's a 60-year-old who should always be with his father and his brother.
I can hear Miss Savage sharpening her pen.
And it's disproportionate to say, well, you're 16, you should have read your English language textbooks. If only you thought about the word ambition a bit more, you'd have been straight down Corridor Luna House.
I couldn't agree more.
And you say it's disproportionate, but you're not prepared to say that.
Well,
You say you don't have to, and Mr. Betts.
you're not here as an additional counsel for any particular person. You're here to make some points which the heir, or however we pronounce it, thinks is of importance in this type of case. How they apply in particular cases is not, strictly speaking, what you're supposed to be here for.
Absolutely. And
you said in your stylus that you are focusing in particular on the facts of Mr. Hasanaj's case, but we mustn't interpret that as meaning you support Mr. Hasanaj's appeal and not Ms. Vasa's. You don't support either as such.
But the great merit from my perspective of the stance that I've adopted is that when one comes to the case of Chelik and you ask why Chelik doesn't apply, I can say, well, in the case of Mr. Hasanaj, there is no double application. The first application and the only application that was made was at the border.
Well, at the moment, I can't quite see why Chelik is something you had to be so careful about, even in Mr. Vasa's case, but that's probably because I haven't understood it properly.
Mr. Chelik failed because he'd made an application once and then sought to raise the substantive points on his second application.
Yeah, well, I'll look at it again.
Paragraph 95 is the problem in Chelik, which doesn't arise in Hasanaj.
Yes, I see.
So you do have the additional fact, in fairness, to distinguish them. If we talk about proportionality, it may be that 9.3 and proportionality is the same in both cases, but there is an additional factor you say in relation to proportionality is that for Mr. Hasanaj, there was nothing he could do. By the time the problem was identified, we'd left. In the case of Mr. Vasa, by the time the problem was identified, we hadn't left. Not only did we not yet left, well, we left, but he was told what to do. So if it may be that is the distinction between the two.
That is the essence of my case, and I say both the principle of proportionality and the general principle of good administration, which applies in this case. We've given a case explaining exactly why it applies, notwithstanding the fact we're outside the Charter, because it's not directed at an EU institution. The principle of good administration applied to member states, and we say those two principles combined must stop a member state praying in aid its own defective system to effectively set up a barrier that makes it impossible in practice for a party fairly to have their application considered on its merits. That's the position.
Now, Mr. Delamere, you might think you could finish in the next 10 minutes, but even I actually have to get to a meeting at 4:30, so we're not going to sit on. How much longer were you going to be, out of curiosity?
I had promised my learned friend I'd be finished by 11 tomorrow. I'm conscious I'm taking more than my 45 minutes. If you tell me to get lost
when we feel we're not getting any help from it, we'll ruthlessly stop you. But I'm afraid there's no question of us finishing your submissions this afternoon. So unless there's something you particularly want to make now, let's just break here.
I'm grateful. Could I make this point? And I know when advocates make these points, you always go quite transparently, but I'm busy. I have other things to do. If there's any way that before I get to my feet tomorrow, you could read the case of Sadiqa if you haven't read it already, that will speed the pen. The central point I want to make in relation to Sadiqa is it's a very, very different position to this case. Why? Because Miss Sadiqa, fully advised, made a conscious choice to choose to go for an EU settlement scheme family permit rather than an EEA family permit. It's not a case of anyone having been misled. It's a case of someone having chosen, eyes wide open, the wrong process, and then saying, in effect, well, you should ignore my choice and you should treat it as if it was made under a different route. That's the guiding rationale.
Very well. I don't give any promises, but I dare say we will. Yes, Mr.
My
Mansell?
Lord, very sorry. One point I should have made in relation to earlier submissions, 1 minute, if I can just say that. My Lord observed in relation to what difficulties could there be if the mistake happened, could it properly be said this redounds to the disadvantage of your client? And of course, the point can be made, leaving aside the questions of disproportionality and the like, also the simple question of costs as well as delay.
Well, I'm afraid this is not a point worth. I don't understand your point at the moment. Make it properly tomorrow.
If you're here, my
we're
Lord.
not under time pressure.
Of course.
Yes,
It's all about timing, my lord. In terms of arguments that's been raised by Mr. Delamere, new arguments that weren't in the skeleton argument, there are various points I need to address. I've timed my submissions on the basis that I was facing the points in the skeleton argument. He said various things that we say are wrong, and I will need to show full authority on that. So
Ms. Smythe, don't, unless you say you're going to want a third day or an adjournment. Despite what we said at the beginning, we were obviously hopeful we would finish by tomorrow lunchtime. If for good reason we can't, well, the things had to. Was it 1.5 day estimate or was it 2 days? It was a 2 day estimate. So if we have to go right up to the wire tomorrow, we will. Although we still hope we won't.
Oh, my lord, I think we will, because I have to correct by reference to authority some of what Mr. Delamere has said. Could I say, given that he's already had 45 minutes, he doesn't take until 11 o'clock tomorrow morning, because I think it's going to be tight as it is.
Well, let's see. Let's see how we go. But thank you for the warning. Very well. 10:30 tomorrow.